Good morning. I'm Senator Judy Ward, Chair of the Senate Urban Affairs and Housing Committee, and I'd like to welcome everyone to today's joint public hearing with the House Urban Affairs Committee on Senate Bill 775 and House Bill 1559. I'm pleased to join with Representative Sue Helms' committee to hold this hearing at the request of Senator Dave Argall on these measures aimed at requiring all potential bidders to pre-register prior to a tax sale and add a layer of transparency to the process and ensure bidders can be screened in advance. We thought a public hearing on this measure would be beneficial to members to better understand the issue and the legislation at hand. We would like to thank our witnesses who have agreed to testify and share with the committee their thoughts and comments on Senate Bill 775 and House Bill 1559. Given our restrained time, we would like to ask our witnesses to limit their remarks to about 5 minutes and summarize your testimony to allow adequate time for members to ask questions. If members have questions of a witness that they are unable to ask due to time constraints, we would ask Senate and House members to submit those questions to your executive director, who can obtain a response from our witnesses following today's hearing. For anybody interested, today's hearing is being recorded and will be available on my public website along with any written testimony that has been submitted. That said, I would like to offer Representative Helm, Chair of the House Urban Affairs Committee, as well as Minority Chairs Senator Muth and Representative Caltadrone, the opportunity to offer any brief opening remarks. Representative Helm?
Thank you. First, I'd like to thank Senator Ward for holding this joint hearing. I'd also like to thank Senator Argall and Representative Heffley for being here as we learn about two very important pieces of legislation in the fight against blight in this Commonwealth. There are many issues surrounding tax sales and loopholes that can easily be exploited by shell corporations and negligent property owners who purchase property at a sale and do nothing further to enhance or even maintain the property. These bills seek to look at this issue. I'm very interested to hear from the stakeholders who are here today about how these bills would make a difference to them on the ground dealing with tax sales and fighting the blight in our communities every day. Thank you.
Okay, and since Senator Muth has not arrived yet, Representative Caltadrone, I don't know if you have some remarks. No? Okay, thank you, and we welcome you. I think there's surplus here. Okay, to begin the hearing, we'd like to give the prime sponsors of the bills, Senator Argall and Representative Heffley, the opportunity to offer some brief comments before calling our first witnesses. Senator Argall.
Good morning, and thanks to the two chairs for hosting today's hearing. I served as chairman of this committee in both the House and the Senate, and so I understand how difficult it can be to seek a compromise on some of these issues. For the last several years, I've chaired a bipartisan statewide blight task force of House and Senate members with other interested parties who work together to fight blight in Pennsylvania communities, large and small. We work with people who deal with this issue every single day. Many of the task force initiatives which have been enacted into law came about because of meetings just like this, where we listen to the folks at the forefront of fighting this battle. Local officials, code enforcement officers, people in our county tax claim bureaus, they are the boots on the ground, and they can tell you, unfortunately, about how people can circumvent well-meaning laws to their advantage. And the issue that we are addressing this morning is a perfect example. I represent Schuylkill County, which lies at the heart of the anthracite coal region, and I see every day at home how economic decline can impact the overall well-being of a community. Many of the municipalities I represent have seen significant declines in population over the last 50 years, And as a result, many homes and other structures sit vacant, fall into disrepair, and end up on the delinquent tax sale list. Just to give you a brief snapshot, between two small boroughs in Shenandoah and Monterey City, there are currently over 800 properties at some stage in the delinquent tax sale process. And these properties become ripe for unscrupulous investors to buy at greatly reduced costs at tax sale or in repository. I've traveled all over Pennsylvania to listen to concerns and to share ideas regarding blight. We consistently hear that local communities are experiencing problems with corporations and LLCs purchasing properties. This has become a popular way to buy property at delinquent tax sales. We have laws in place to prevent negligent and unscrupulous property owners from buying new properties while their other existing properties lie in a serious state of disrepair or are tax delinquent. But unfortunately, some owners, and it's only some owners try to circumvent these laws by using numerous corporate names when purchasing properties at these tax sales in order to hide their identity. This allows the purchaser to hide behind the corporate veil, making it difficult to cite the appropriate parties for code violations and to hold them accountable. It also allows them to continue buying properties while avoiding their tax obligations on other properties which they already own. Many of these properties have been sitting empty for years, and when someone purchases one of them, it's often already in decline. And so if it's purchased through a corporation or an LLC, there is no way for a code enforcement officer to track the actual owner. And I recognize the value of our corporate laws. I also know they were not created to give negligent property owners easy cover in order to avoid prosecution for serious violations. This morning, you're going to hear some firsthand testimony from the folks who deal with this problem every day. I applaud every one of them for their hard work and effort and thank them for joining us today to share their experiences about what is really happening. And again, to the two chairs, thank you very much.
Thank you, Senator Argel. Representative Heffley, would you like to offer some comments?
Thank you, Senator. As a representative from Carbon County, we have some communities, as every district does, that have some blighted properties and blighted areas. I think it's important to note that, talking to an engineer one time, he said to me, he said, anything you put in the ground or you build, the second it's built, it starts to deteriorate, right? So every community eventually is going to deal with this at some time, some sooner than others. So trying to give our communities the tools that they need. And I want to thank Chairman Ward and Helm for holding this hearing today, and Senator Argel for all the work that you do. Before the testimony from the stakeholders who are here, I'd just like to say a few words about my bill, which is a companion piece to the Senator's Bill SB 775. House Bill 1559 is primarily aimed at creating more accountability for bidders at tax sale, as well as assisting municipalities in fighting blight and piercing that corporate veil and negligent property owners hide behind. The bill creates a pre-registration requirement for potential bidders, and any potential bidders must appear at the Tax Claim Bureau no less than 14 days before the scheduled sale. Registration requires providing contact information, a signed affidavit stating that they are not delinquent in any tax or municipal utility bills, or that they are engaged in any unsafe property management activities. The Tax Claim Bureau then provides a list of applicants to the municipality at least 10 days prior to the sale to verify that bidders are not delinquent on taxes or having outstanding code violation. The reason that the pre-registry is so important, because under current law, property owners who are delinquent on tax sales otherwise are not permitted to bid at tax sale, but yet they can easily bid at the sale and purchase the property. It is then only after the sale that counties may realize that the individual is prohibited from purchasing property at a tax sale. This allows the counties to identify any potential bidders who are not able to bid prior to the sale instead of trying to play catch-up after the property is already sold at the tax sale. I'm aware that there have been questions regarding a provision of the bill that prohibits family members of the property owners from purchasing the property at tax sale. This is a result of a hypothetical scenario where property owners who, for personal reasons, have not been able to keep up with their taxes and have a family member repurchase a property to allow the owner to remain in the property. I believe that it's important to note that the language of this bill does not remove the right of a family member to go to the county offices at any time prior to the sale and pay the back taxes so that the owner can remain in the property. As such, I feel that this concern is invalid, as there is plenty of time and recourse available prior to the sale that would allow the family members to keep the property in the family, and that would be easier than allowing the property to go to tax sale. I'm also aware that there have been concerns raised about the amount of time that potential bidders need to register prior to the sale. The reason the bill is set at 14 days is to allow the tax claim bureaus enough time to compile a list of potential bidders, allow the municipalities to check their tax records, and provide time for counties to review the list. To expect that to happen in a matter of hours, in my opinion, is unrealistic, though I do agree that maybe some discussion can occur on how the time needs to be compiled. The final concern that has been raised about my bill is regarding the applicability to the city of Philadelphia. I'd like to note that Philadelphia is not under the real estate tax sale law, which my bill amends. Therefore, this bill does not apply to Philadelphia. If anyone would like to make a similar change to Philadelphia's tax sale laws, I'd be glad to co-sponsor such legislation. With that said, I'd like to note that this bill is a priority for the bipartisan statewide blight task force this session. Again, thank you for allowing me to say a few words about my bill and the importance of this fight against blight across the Commonwealth.
Thank you, Representative Heffley. Now we'll call our first witness. Our first witness will be Dave Patton, who's the Code Enforcement Officer for the City of Harrisburg. I'd like to welcome you. And yep, that's great. And just make sure the green light is on your microphone there. And you can begin whenever you're ready.
Well, I appreciate being here to speak on what the when the repository sale occurs, the municipality gets the opportunity to at least have some level of screening. Right now, we don't have that with judicial sale. We have to wait until the actual deed transfers, and then we have to go to the Law Bureau our law bureau, and petition the court for a set-aside sale. So we got to waste municipal time, we have to wait county time. We need to have that ability to screen some of these individuals. And it's not a panacea solution, but it is very important that this legislation go through with the strength that it was originally designed to do. A lot of what happens with the repositories, and like I say, the internet it's absolutely horrible, because especially with the repository, we've had people sit in their Florida home with a laptop and just buy properties off the internet. They don't even have to show up. They just submit them whatever documentation, and next thing you know, I have properties, owners, and they're sight unseen. They don't even look at them. They look at none of these properties. As far as the comment, I'd like to comment on the 14-day time frame. I mean, that's extremely important, to have ample time to have the county accumulate and get all the necessary information from the registrants. And I have to have time to be able to go through and just at least, vet some of these particular owners, so we're not getting to this particular point. Because absent having the strength of the way this legislation was originally designed, then this legislation, you might as well write it on water, because it's not going to have any, with this effectiveness, it's not going to be effective at all. Any questions?
Are there any questions from the members? Representative Lewis.
Thank you for being here. And I think this is such an important issue to address with the rising problems of blight, and especially as a Dauphin County representative, very vested in what happens in the city of Harrisburg. So I do have a couple questions. Before I ask them, I do want to recognize I have an intern here, Anna, who is shadowing me for the day, and also a district aide, Eric Rivers, as well. So welcome them to the committee. You talked about, and just to frame this, I'm supportive of the concept of, very supportive of this concept of really dealing with these tax sales so that their advantage isn't being taken to the system. That being said, I'm slightly concerned to add a layer of making it more difficult to bid on tax sales, when my understanding is once a property is purchased, one of the first things that has to happen is the back taxes have to be paid. When you talked about the Friends and Family Plan, how a property was recently purchased by a family member, ended up back in the hands of the owner, were the back taxes paid in that situation?
When they buy a judicial sale, they can get them free and clear. All they need to do is file a filing fee for each action. You file a filing fee for the lien, you filing for the back taxes, whatever. It's like $20-some per action. So they walk out of that free and clear. The only thing they pay is the auction price. That's what I'm saying. A lot of these, they ended up sitting and become delinquent again, and then revisit. And after 24 years, I've actually seen properties come through for the third time.
So they can purchase it for the auction price, transfer it, and never pay those back taxes. Is that what you're saying?
They can, but they don't.
Okay.
That's the whole purpose behind a judicial sale, as the same as the repository. Repository, it's automatically, you don't have to, everything's wiped clean. But with the judicial, you pay that filing fee, which everybody does, and that way they can get that property free and clear. Otherwise, it just ends up back on the tax sale in a shorter time frame.
Okay. I had, in last question, if I may, Madam Chair, I have introduced an amendment to this. I wanted to get your thoughts on it, and as well as any thoughts that the other members had, and see how you feel this would kind of address the problem, protecting the legitimate actors who want to invest in these properties and develop them and get rid of the blight and then rent out these properties. One of the changes I was hoping to make was to change the definition of person within the bill to anyone residing outside of a 250-mile radius, because I think the problem is folks bidding on these properties that don't live in the area, have nothing to do with the area, and it's like kind of a ghost bid. You send in the bid, and so this would kind of eliminate that problem by saying, this applies to you if you live outside of 250 miles, and also it would enable you to register online as long as you designated someone in the Commonwealth to be responsible for that property. What do you think of those changes? Does that still move us in a good direction, and does it help to solve this problem while protecting legitimate investors who may not have the ability to come to the courthouse 14 days out and do a registration? What do you think?
Well, quite honestly, whenever the internet's involved, it becomes a problem, because although you can designate someone, we have that same sort of situation with rental properties. You can designate someone, but then all of a sudden they're not a designated person anymore, and they dissolve whatever partnership they have. And I'm back in the same church, different pew. I'm back with an owner that's out of state. New York was very popular. For whatever reason, judicial sales, they travel down here from New York and buy these properties. And they're never for noble purposes. I have one individual that even locally who lives in an apartment, he bought a block of 6. I mean, there has to be some type of vetting process that we can go through. The internet has been a problem, especially with the repository. And in all candor, you know, you can designate someone, but they can dissolve that designation status at any point down the line, and I'm going to have the owners in Australia and all over the place again. So I'd rather have them, you know, they're going to appear, and even when they do appear now, we still have that problem. It's just our biggest problem is I can't vet them beforehand like I do the repositories.
Last follow-up question, if I may. In your mind, are there any concerns on your end of this creating this kind of difficulty with, say, a businessman or investor, businesswoman wants to purchase these properties, but they're unable to come down to the municipality or to the city and register, so they're not able to. So you're having a lot of properties that are not purchased by valid, good investment type scenarios. Is there any concern in your mind that this would it would hamper that process, and then you just have these properties sitting there with uncollected back taxes? Yeah,
no, I think that's a good gauge of their seriousness of wanting to rehab a particular property is to actually show up in person for it. Most of them don't even, if they can't show up in person, then obviously they haven't even looked at the property. And that's generally what happens a lot of times. They don't even look at them. They'll look at a dated Google Street View map. You know, I always use the analogy, you know, whenever something comes through the repository, it's condemned. And we have a lot of condemned properties that on the tax sale. You know, I always make a personal phone call to them on the repository. Have you looked at this property? Do you realize it's condemned? Well, no. I said, have you looked at it? I said, no. I said, well, let me ask you this. Do you drive? When you bought your car, did you just buy it assuming there's an engine in it? Or did you just buy it, you know, sight unseen? But most of the ones are bought sight unseen. Having them there physically, and not all the times they do look at the properties, but most oftentimes they don't even look at it. So having them there, I think, gauges their seriousness as wanting to do something with that property. Because right now, everything's happening. It's at the hardships of the citizens of Harrisburg. These properties just sit, and their fire insurance gets canceled, their homeowners insurance gets canceled, and they just sit and they sit and they sit, while they get freaking flyer miles being sold throughout the country.
I appreciate it. Thank you.
Representative Helm.
Thank you. You talked about the time frame to register.
Yes.
In the bill, it says a person that intends to bid at a scheduled sale must appear and register at the Bureau not less than 14 days before the scheduled sale. There is another amendment out there that is asking to lower that to 36 hours. Could you give your comments on that?
I mean, that would be such an unreasonable time. Say if the spring sale was over 230 applicants, registrants for the sale. That means, you know, the county has to go through all their paperwork, and then it has to come to me, and then I have to go through all the vetting procedures that I go through. That would be such an unreasonable amount of time. It would just spearhead the whole intent of the legislation.
Thank you. And having sold real estate for years in Harrisburg, believe me, I want this to be cleaned up.
I've talked with you.
Thank you so much. I have a question. How often does the city file a petition to reverse the sale?
Last time we did a set-aside position, and this is, you know, with the change, this is my third administration, and unfortunately the Law Bureau hasn't been, with the rotation and the revolving door there, we haven't been able to do set-aside petitions. The last one was 2006, where I reversed the sale of three properties and took that set-aside petition, and whenever they paid for that, they took that money and put it toward their already existing back taxes. That was the reason why we did a set-aside. They had back taxes. Now, most of the times with a lot of these purchasers, you're not going to see a lion's share of the back taxes and everything, but you do see a lot of the code violations that exist that are public safety related that give me the grounds to do set-asides. I just don't want to have to, I mean, that's just such a labor-intensive measure to file a petition, to waste the court's time, and then have the individual come in and have a hearing, and it's just very labor-intensive. We just want to do it the same way as we do the repository. Just have those reviews at the beginning.
Very good. Any other questions from members? Representative Lewis.
Can you talk me through the process of vetting if a buyer registers, if they say they do this 14-day, what is the process that you would have to go through to vet them, and how many on average right now do you decline based on their past history?
I haven't had the opportunity to decline a judicial sale. I've declined quite a number through the repository sale, but once they come in and register, I'm supposed to get the list of all these individuals and their addresses. That goes through our Treasury Department to look for any kind of back tax and utilities. I, in turn, go through all of our database to see what, if they're a bad actor or a good actor or what the situation is. And again, what's nice with doing the way the procedure with the repository, not that it's perfect, but I personally call. I reach out. I have their phone numbers, in that repository, and I reach out. Say, do you know this is condemned? Do you know this is on my demolition list? I want you to go into this with eyes open. And a lot of people, they decline the sale then. I don't have that opportunity even though I have the Dauphin County system updated to denote condemned. They even have a document that I created, a legal document that they sign acknowledging that this property is condemned or can be condemned. And sometimes they still buy it. I show up at the sales. The sales are crazy. It's like a bazaar. I've actually had people come up to me and say, "What does condemn mean?" And I just go away.
Senator Laughlin.
Thank you, Chairman. Mr. Patton, thanks for being here today. The city of Erie falls within my senatorial district, and we have significant blight issues as well. And one of the things that our city council did recently was passed a quality of life ticketing program, and I didn't know if you had heard of this or if the city of Harrisburg has anything similar to it. And the reason that I find it a significant tool in fighting blight is because as a code enforcement officer, you're aware that you can write somebody a citation, but it might take a year or two or longer to get any action out of that.
Yes.
But this quality of life ticketing that the city has enacted in Erie is more like a parking ticket where they can just write them a modest fine to get something taken care of, and it's from what I understand, it's a much quicker enforcement tool that might help in this fight at least. I know that's not why we're here today, but I thought I'd ask.
No, I'm familiar with the program, and actually, in all honesty, all it is a more fashionable term than instant citation. We do the instant citations, and it's critical that we issue the citations with the date of births, with all the necessary information has to be on that particular citation for it to go to warrant. So that's why I've enacted the instant citation in 1999. And now it just became fashionable to say it's a ticket system. I know it's for high grass and weeds, snow removal, and sanitation, but having that citation with all the necessary personal information, social security, date of birth, all those sort of things, that gives us the ability that when somebody stops for a warrant, they get stopped for a traffic stop, they have all the information in JNet, that they have a warrant for their arrest.
All right. Thank you.
Representative Dush.
Thank you. And Mr. Patton, I appreciate your testimony. I have one quick question as relates to your investigations. Whenever you're trying to find out if they're in delinquent status, is your scope limited to just the Harrisburg City, or can you look elsewhere in the Commonwealth? And you said people coming from New York. Are you able to, when you're vetting these people, reach out to those other jurisdictions and find out if they're delinquent in other areas?
No, that's difficult to jump across state lines. Since I have some of the Department of Public Safety and part of the police department, I have the access for county-wide search and outside whatever compatibility our certain in-sync system has. And also I have the justice system, so I can go statewide in terms of JNet to research and see if they have any outstanding warrants relative to, property maintenance issues.
Thank you.
Senator Street.
Good morning.
Morning.
Question. So, the concern that you have, just make sure I understand it, is that there are parties purchasing properties in the city of Harrisburg that are just speculating on them and not doing anything with them?
That's absolutely correct.
And the belief is that by vetting the parties, you could prevent speculators?
I can narrow the playing field. I can't absolutely, say it's a panacea solution, but this gives me the opportunity to at least reach out to the individuals, because a lot of them, people that buy some of these condemned properties, they have no idea how the world is going to change and what our capabilities are. I mean, I can go misdemeanor, I can put them into the National Crime Information Computer for public nuisance, for reckless endangerment, whatever the case may be. So it gives me the opportunity to reach out to these individuals so they go into this with open eyes and not all of a sudden they're getting all kind of mail and charges levied against them that could impact their employment. I mean, because when I put them in the National Crime Information, it goes nationwide. Anywhere they go, a warrant's going to pop up. At least I have the ability to reach out to them and just narrow the playing field a little bit.
So when you say narrow the playing field, how would that conversation go? So if I was a prospective purchaser, I register, what kind of question would you ask me?
I would ask them, one, if they know that the property is condemned. Do you realize that this property is on the current demolition list of the city of Harrisburg? This is what happens when the ownership changes deed. You're going to get a condemnation order. You're going to have a prescribed time to act, either to fix or repair that property. If you don't, then the situation goes bad. It elevates to a citation. It could elevate to this. If the property collapses while it's under your ownership, you're looking at this, you're looking at that. So I lay everything out for them as to what they're staring at, if they go down this path, so that they go into this with eyes open. And sometimes they do, a lot of times they don't, but at least I like to have the option of at least giving them the option of not having a life-changing purchase.
And the idea would be that they would know what the responsibilities of owning a dilapidated property are.
Yes, sir.
And they would therefore, and so that a person who is not interested in meeting those responsibilities wouldn't purchase.
That's correct, sir.
And the belief is that there are other folks who may be lower bidders who would then purchase and be more likely to be responsible, or?
I mean, anybody can put, any property, regardless of state, if they have enough money, they can rehab a particular property. Does it, withstand the market value of that particular property?
No, what I'm getting at is, so what happens is, let's say I just say, oh, you know what, thanks, I'm not buying the property. I'm not going to bid.
Okay.
So you've removed a bidder.
Right.
The property still sits in the same dilapidated condition.
Correct.
I'm trying to follow your logic. So the premise would be that a bidder who would have been outbidded, because if I'm not going to win, then it has no effect on the process.
Mm-hmm.
So presumably a lower bidder would win and be more likely to be responsible. Is that the basic premise?
Usually when you have the auction price, once the sale is concluded, it doesn't go to the next lowest bidder.
No, but
I mean, somebody conceivably could.
Right, but I'm talking about the effect of the effect of this legislation would be to remove bidders before the auction takes place.
Correct.
And so in order for it to have had any effect, there would have to have been someone who then purchases it and conducts themselves in a responsible manner as a consequence of this legislation. Other than that, all we've done is reduce the amount of money that's collected and given to the and remitted back to the municipality, and we haven't effectuated any real change in the condition of the communities that are represented. I mean, I represent a lot of areas that have dilapidated properties, and I was counsel to the sheriff of Philadelphia, outside counsel for a number of years. I'm familiar with the process. I'm trying to understand how you believe the effect of this bill is going to increase and improve the situation, and that is the direction of the question. So the question is, it is your supposition that when you eliminate those bidders who don't want to, that these bidders tend to be the high bidders, and that some lower bidder is going to be more responsible?
I can't say who's going to be more responsible than another. I know once that property exists, and we vet out, it ends up on my in-house demolition team. I run an in-house demolition team. We're finally starting to see the light with a lot of these properties, but we can't, it's hard to breathe. With all the people coming in and speculating, we got to start over and start over and start over and start over. It's so increasingly labor intensive. We're just wrapped up in hours and hours, and we spent so far 48 days cumulative hours in court on a lot of these properties. We're just trying to eliminate some of these potential purchasers that don't have any noble reasons for owning them.
Thank you.
All right, Madam Chair, one last question. I indulge patience, and and I'll just this comment. Look, I understand the need to want to reduce the number of bidders who are not responsible. I'm just, and I would maybe at another time because I know we're out of time. I've not understood how you've established a connection between how this will accomplish that goal for you, and that's not to say it isn't, but I just haven't gotten that answer.
And maybe Mr. Patton will be available after the hearing. Representative Dush.
Thank you, Madam Chair. Just a quick follow-up. Mr. Patton, do you have access, and you're talking about JNet, do you have access to actually place warrants? And number two, do you know how often people who are in your situation, in your type of position around a Commonwealth avail themselves of that if they have such access?
I'm actually one of the only people that has access through permission from the district attorney's office to have access from that broad spectrum of databases.
So you've received yours through the district attorney's office. Does that happen in other jurisdictions that you're aware of?
No, it does not.
I think it's probably a good idea that we should be able to do that. Thank you.
I've actually imparted some of that possibility to other ones that I've done assessments through while working through DCED on local government services assistant, and they were a little reluctant to grant any kind of access because I can get PennDOT, I can see if they're getting checks from assistance program, if they're going to a different type of address. So I have a broad level of just searching for people. That's one of the biggest things, is just trying to find people. They're so easy to hide. I spend a lot of my time, hours, just going for search for people. LLCs, that's a whole nother game.
It's a very effective tool, and I greatly applaud you for the way you're going about it. Thank you.
Okay, seeing no other questions, we're going to continue on. Thank you so much, Mr. Patton.
Thank you.
We appreciate your time here today. Next, we have Crandall Jones, who is the Municipal Administrator for the Municipality of Norristown. Good morning.
Good morning.
Thank you for being here today. If you can just make sure when you're speaking that your microphones, the green light is on with your microphones.
Absolutely.
And you can begin when you're ready.
Thank you so much. Thank you very much, all of you, for allowing the municipality of Norristown to have an opportunity to talk about this very important issue and this legislation. I'll also introduce with me at the table is the brains of our operation as it relates to code enforcement and building issues in Norristown. This is Mr. Amrinder Singh, who is our building and codes manager for Norristown. Certainly, Mr. Patton covered a lot of the issues that we experience in Norristown, so I wanted to kind of paint a quick little picture of Norristown and the issue we have related to this problem and why we're really excited about the original legislation that was put together. And again, thank you for your consideration of this legislation. Norristown is the county seat of Montgomery County. We're about 3.5 square miles. We are very dense. If you go to the census, it will say that Norristown at 3.5 square miles has 34,000 people. Actually, it's probably closer to 50,000 people in Norristown. And over the course of the last 10 years, what we have seen is that a community that was once 60% home ownership, 40% rental, is now 60% rental, 40% home ownership. So we have a lot of issues related to blight that we've been dealing with. One of the most recent stories we had was a row of properties that had burned down probably about a week before I came to Norristown as a manager, which was in 2013. Those properties still remain in disrepair in 2019. But those properties got purchased, and we actually went through the process of trying to get the property owners in that row of properties to deal with them. And it was very, very difficult. So probably about a month and a half, 2 months ago, 3 months ago, we gave notice that these buildings are imminently about to collapse, and we need you to deal with them. And we tracked and finally found one of the owners who gave us lip service that he was going to deal with, and ultimately we had to take the property down because it was an imminent danger to the community. We did so. The properties next to ours needed to be taken down. That property owner, which happened to be Habitat, who had great intent, went to take that one down, and as a result of that, 3 properties collapsed. And people on the end who were already there complaining about the connected bad properties ended up having to vacate their properties because of the collapse. And we're still in the process, one, of trying to, at least Habitat is trying to help make them whole. And number 2, we still do not and have not recovered our expense for having to take the properties down. And we do that consistently. As a small municipality, one of the poorest communities in Montgomery County, we actually don't have the luxury of having a whole lot of money that the municipality can devote to demolition. And certainly we put something aside every year, but as you know, certainly the recovery of those funds is a whole nother matter, particularly when you're dealing with absentee owners who are, as was previously said, bad actors. A few of the statistics I'll share real quickly with you is that 37% of our properties are owned by outside entities. And so they're not local people to Norristown or even to Montgomery County to a large extent. We have owners of properties that represent 30 of the 50 states in the country. We have over 600 mailing addresses for these owners, and it is incredibly difficult to track them down. About 17% of those property owners, which is about 1,700, almost 1,800 owners, are corporations and LLCs. We have property owners who have multiple LLC names and addresses, and it's very, very difficult to find someone who we can hold accountable to this. Very quickly, as relates to the 14-day period that was originally introduced, we support that. We think it does give some chance at being able to hold these folks accountable and track them down and vet them properly. I think certainly in Montgomery County, the current honest system of an affidavit we think is not thorough enough in terms of being able to vet folks who are interested in obtaining properties. If ultimately that there's a move towards shortening that 14-day period, rather than go to an honor-based affidavit system, we would recommend that maybe you consider having a certificate of good standing that maybe comes from the municipality where we've done our work with the prospective buyer in advance, so that at least when they go for the sale, that they have some record on hand that the municipality has pre-screened, and rather than rely on the honor system where we all end up on the back end of it trying to track it down. I think those are the comments that I'll make initially. Certainly be welcome to try to answer any questions you have, and I'd again say I'm going to always punt over here for the technical questions. Thank you so much.
Thank you so much. Representative Heffley.
Thank you for being here, and thank you for your testimony. You had mentioned something that sparked my curiosity, the certificate. So if you have people that folks may go to a lot of these tax sales of businesses that this is their model, and they're doing the right thing. But yet every 14 days they got to go in and you have to research it. So if you're looking at a model of to say, well, maybe if you're a frequent purchaser, you get a certificate, or if you're in good standing, how often would you need though to follow up to make sure that they didn't, in the last, say, month or 2 months or 3 months, fall behind on some taxes or some other issues? That was just my question. How could that be managed if you come up with that certificate? Would it be like for 3 months or 6 months or a year? And how would you then just verify that property owner who was always in good standing didn't somehow fall behind?
Go ahead, I'm here now.
Thank you. One of the ideas that we had was that just like how Montgomery County requires bidders to register at least 1 day prior to the sale happening, what the potential bidder can do is reach out to whichever municipality they are wanting to purchase any property at, and reach out to that building department or the finance department and reach out to them and request a certificate of good standing, where the finance department and the building and codes department would be able to do the research and hand them a certificate prior to each sale. So the certificate, we would not want it to just be a blanket certificate for 6 months prior to them going for every sale, which usually happens once a month, once a quarter, or if it's a repository, it can happen at any given time, that they obtain that certificate from whichever municipality they want to purchase a property at, and then be allowed to register to bid for that property.
So you would say that they wouldn't have to show up, they could just call or register if they have that certificate?
I mean, they would be able to fill out the application if they want to submit it to us online or in person. It'll make the process a little bit easier. The whole purpose is we want to make sure that responsible property owners are purchasing these properties. So if we are able to vet them, and if they don't need to come in, I think that would not be an issue. But if they come in or if they send it to us online, we can go through their records to make sure that they don't have any taxes that are delinquent, that they don't have any properties that are in disrepair or have any open property maintenance issues, or have any of their licenses revoked for housing.
Okay, we'll follow up afterwards. I have a couple more questions on that, but thank you.
Thank you. Representative White.
Thank you, Chairman. I had a question regarding what means do you go through in order to attempt to get the monies back when you do the demolitions?
Well, we certainly put a lien on the property. We do diligent searches of trying to locate the owners of the property as well. But as you know, the problem with liens is if there's not going to be any movement on the property in terms of a transfer or sale of the property, then we're just in kind of a wait mode as far as that's concerned. We've certainly been working now with Montgomery County, and we're under discussions about land banking property and creating the opportunity for us to put properties like this in a land bank so that they ultimately can be sold. And as a result, we're dealing with the discussions of eminent domain and takings, et cetera, regarding that and property rights. But we think land banking is an option for us.
The other thing, I know earlier you had brought up, a large percentage of your area has been comprised of renters, people who are owning these, locations, and then they're renting them out. And truth be told, I mean, the millennial generation, that's like what they do, and that's been the trend over these past several years, is just that they like renting. So I don't know how this legislation, in your opinion, would assist that generation in terms of being able to get these rental properties.
Well, we do a lot now in terms of development, and good property owners, good actors do provide for millennial housing. We built recently new projects, millennial housing projects in Norristown over the last 2 or 3 years. So we're actively participating in it. Our concern is about these properties that get in a state of blight and disrepair. We have some owners who are and developers who are really, really excited about our location. You know, I think we are a millennial haven in terms of our transit. Being a transit hub and being close to Philadelphia, being close to King of Prussia Mall, so we're seeing a lot of millennials come in. The problem is we have, we think, some good housing stock that is going to waste and falling into a state of disrepair by a lot of bad owners who are not making it available to millennials and others who want to purchase the property. So for us, if we can get these properties into the hands of people who are actually interested in working on them, we have an active home program where we work with folks to do improvements on the property. Biannually, we bring in 400 volunteers to help with properties in a state of disrepair, so that we can encourage renters, owners, whoever to have occupants in the properties. It's this 300 or so in Norristown now, 300 or so properties in Norristown now that should be demolished. And those are the ones that we're trying to prevent folks from just holding on to and taking us through this process.
So do you think that maybe we should be giving you more authority to, you know, if there's a lien on a particular parcel where you did demolish it, do you think we should be giving you more authority to say, you know, maybe not necessarily preventing people from being able to bid on these properties, but instead give you the authority to take over the ownership sooner, or give you more authority in that capacity instead?
I think the authority should be directed toward dealing with the owner, the original owner. The one thing that we as a municipality don't want to do is own the property, because obviously that takes it off the tax rolls and lowers our ability to be sustainable. But certainly if from giving judicial authority the ability to take stronger measures with those bad property owners, and if we can do things administratively to facilitate that, we certainly support that.
Okay. Thank you very much, Chairman.
Thank you. Representative Lewis.
Thank you. Thank you for being here, sir, and for your insights and for taking time out of your day to be here. Question, on the 14-day registration, as these potential purchasers register and you're vetting them, how subjective is the vetting when it comes to, is there clear criteria that they need to meet? Who has the power and the authority to say, no, you are not an approved bidder, and what is the criteria that they have to meet?
I'm going to let Andrew answer a part of this if need be, but one of the things I'll say, what we're looking at is objectively. Do you have back taxes in Norristown? Do you own properties that are in a state of disrepair? Do you have existing liens that you haven't paid? Do you have trash bills related to those properties that you haven't paid? So it's all very objective in terms of what's important in the municipality. If you're a good actor and you want to buy a property, and we work with plenty of them who want to buy a property, by all means do so, and we'll do everything in our power to do it. But if you're a drag on the tax rolls, if we're carrying your debt to the municipality for the services we provide, then no, we don't want you to add to that burden.
Fair enough. And just to follow up, my concern, because it does sound like you have a very clear cut in your municipality, and then in Harrisburg, Mr. Patton, very much a clear-cut methodology and way of analyzing this. But it sounds like it would differ based on your municipality. And I think there are probably in other municipalities across the state, I assume there may be somebody, a code enforcement officer somewhere or an administrator somewhere who may have a certain bias toward this developer versus that developer and might use this as an opportunity to kind of say, well, I've got 14 days to vet you. These guys I don't want. These other guys I do want. My fear is that may happen. That could be an unintended consequence of this bill. versus having a very clear criteria for who qualifies, who doesn't, that's consistent across the board?
Well, and I will thank you for that observation. I'll say for the municipality of Norristown, and you know, we're, I guess, medium-sized by Pennsylvania standards in terms of a municipality, but from a working with a developer standpoint in terms of projects, that's not vested in the codes department. They play a role in terms of permitting and inspections, et cetera. But in most municipalities, you know, and I'll yield to very small ones, but in most municipalities, the whole interface with the developer, particularly in our instance, is myself, our planning and development director, and it is all based on objective criteria. It's not about their developers I absolutely can't stand in terms of personality, but do you do your business correctly in Norristown? And I think you'll find that in most municipalities with the appropriate staffing, that's the case.
Thank you. So I've actually had the opportunity to work in Berks County, Dauphin County, as well as now Montgomery County. I worked for the city of Reading. I worked for the borough of Steelton right here in Dauphin County, and now for the municipality of Norristown. And at a building and code department, our goal is not to have vacant properties. We actually want every property to be occupied. We want properties to be code compliant. So if we have a potential bidder who is going to be a responsible property owner, we will do everything we can to help expedite and facilitate the process for them to be able to purchase that property. But if they're a person that's known as somebody that's continuously not maintaining their property, or somebody that's just going to purchase a property and let it sit for many years while they're planning or working on getting funds to develop that property, we would much rather they not be able to purchase that property at the tax sale, and they actually go to somebody that's a responsible property owner right away, because we get numerous phone calls from community members on that block saying, why isn't codes doing anything? Why is this property sitting this way? And when we tell them we can't find who the owner is, or this person just bought this property, and I know I've mentioned this in a previous meeting with Act 133, how we have to give property owners a whole year to fix this property. They look at us like we're crazy giving people a whole year to fix the outside of their property. And you know, we want people to be able to enjoy their blocks. We want to help raise the quality of life. We want to help maintain and increase property values. But it makes it very difficult when we have shadow LLCs and corporations buying these properties and we're not able to track them down and hold them accountable, because even if we do issue citations, they don't go anywhere. They're using P.O. boxes. We don't have an officer name. They're just going to sit there in a warrant status. And for example, in Norristown, 40% of the citations we've issued in the last 3 years, they're just sitting in a warrant status. There's no accountability being held. So these bad actors, they just continually keep opening new LLCs, using virtual addresses, using P.O. boxes to keep getting away with this over and over. And it's not just happening in Norristown, it's happening in every community across the state, unfortunately.
Thank you. And it's clear to me that you are doing a tremendous job, and that's why you're here. My only concern was in some municipalities that I've seen how they are run, I hesitate to tilt the balance of power in a way that could be disadvantageous to a legitimate, good investor who wants to come in and benefit a community. Thank you for your response. Sir.
Thank you so much. Senator Argel.
Thank you, Chair. It's very appropriate that Norristown is represented here today, because as I told you at the last meeting of our bipartisan task force, Norristown is where this effort really began decades ago after a terrible fire, and Representative Fichter brought these interrelated issues, and the end result was dozens of meetings, dozens of public hearings all across the state, dozens of new laws. I think at one of those meetings, Representative Wright from Lower Bucks County pointed out to all of us that any community, large or small, east or west, wealthy or impoverished, is going to have blight, because every community is going to impact some kind of economic issue somewhere. And so I guess to follow up on all of the bills that we've passed, I mean, millions of new dollars for counties for demolition, conservatorship, land banks, expediting bad actors from out of state. I want to follow up on Senator Street's question. If we pass this one bill, because this has been an incremental process, piece by piece by piece, but if we passed this one bill, how would things change in Norristown or upriver in Reading or Pottsville?
Thank you. I think it would really be beneficial. For example, just on our September 26th upset sale, 20 of the properties that were on the upset sale, out of the 28, 14 of them, so 50% of them were owned by LLCs. So they just let their property sit there and deteriorate. And so this is going to be a great addition to all of the great things all of you guys have implemented, all of the tools you've given us in our tool belt to help fight blight. So this is going to be an additional benefit to codes departments and building departments across the state, and this will help make sure that more responsible property owners are being allowed to purchase these properties, and it's going to kind of weed out the bad actors. So we would really appreciate if you guys would look into the recommendations that were made by the Housing Alliance and some of our other partners across the state, as far as not really going from 14 days to 36 to allow municipalities enough time to gather the data, to go to sort through the data. And if you are willing to make it 36 hours instead of 14, requires some type of certificate of good standing that the bidder has to obtain from the municipality. That way, even if it is 36 hours, the due diligence is on them to get that certificate to be able to register in such a short amount of time. And then also the other item mentioned was 250 miles. Now from Pittsburgh to Philadelphia is 305 miles. And like we just mentioned earlier, a lot of the property owners in Norristown don't even live in Norristown or Montgomery County. So if something happens at your property or if your property needs to be maintained, 250 miles is a long way for you to carry your weed whacker and your lawnmower to maintain your property or shovel the snow. So if there was some type of additional wordage or verbiage that can be added to possibly reduce that or require some type of formal requirements as far as obtaining a realtor or a professional property manager, not just being able to just designate anybody to be a responsible person, but actually have some type of credential. That way there will be some type of follow-up, and it's not just something that's being put on there that where you can make, you know, your friend from high school or your cousin or somebody just a responsible person just to be able to purchase this property and then let it sit there and just deteriorate.
If I might also just, I think one of the things in Senator Argall, you hit it right on the head. One of the things that this legislation adds to the tool belt is an opportunity to further stabilize existing neighborhoods. What we see with these property owners, is, these bad property owners, is so much destabilization of good neighborhoods, of folks who are trying to do the right things in their communities, and bad actors come in, buy a property, don't improve it over time, and of course the property values continue to go down. People decide it's not going to get any better because codes is doing everything they can, but nobody understands we're limited as a municipality in what we do. So we think that this adds another rung, leg to the stool of trying to stabilize neighborhoods and communities.
We're getting short on time. We've got time for two more questions. Representative Rothman.
Thank you, and thank you for being here. First of all, I wanted to, you mentioned 37% of Norristown properties are owned by non-Norristown residents. I don't think that's unusual. I mean, I represent a very suburban district in Cumberland County where 45% of our properties are non-owner occupied, and most of those are owned by people who live outside of the district. So I'm not sure that 37% is necessarily a bad number. But I am concerned about, or curious about, your thoughts on why we're limiting this just to tax sales. I mean, if you have irresponsible property owners or bad actors, do you think that we should extend this to private sales too, and you shouldn't be able to buy a property in Norristown if you're not responsible, and if you own other properties? And I think the bill as it reads, it's not just delinquent taxes in or code violations in your municipality, but it's throughout the Commonwealth. So would you support extending this to all sales and all ownership?
I'm not sure that certainly we should get into private market in terms of all sales, but certainly when you've got properties where we have history of bad behavior, where we have a history of deterioration, where we have money uncollected on our tax rolls, fees or fines uncollected on our tax rolls about that, and we can identify particular entities or groups of entities that have some impact on doing that, I think certainly we should deal with them. I think just in terms of general sales and somebody coming into the market privately wanting to buy, I think it's America and they should have the right to do that. If they become bad actors, then we'll deal with them afterwards.
Thank you, Madam Chair.
Thank you. Representative Heffley.
Just to follow up on that last question, I would say that mortgage companies aren't going to give a mortgage. They have to have a home inspection. There's a whole different set of criteria than that. And that's not really what the bill deals with. But I wanted to, Representative Lewis had mentioned about the criteria, and that is in Retzel. The criteria. So when you sign that affidavit as to what the requirements are to qualify, you're signing an affidavit that you meet those requirements. It's already in Retzel. It's already in statute. So we're not setting the bar higher or changing everything. That's already there as to what the requirements are and who would be able to bid. I just wanted to clear that up. Thank you.
Thank you so much. Thank you, gentlemen, for your testimony. We appreciate it very much.
Thank you.
Yes, thank you for being here. Our next witness will be Lisa Schaefer, Acting Director, appointee with the County Commissioners Association of Pennsylvania. Lisa, thank you so much for being here. Just make sure your green button's on there.
Good morning, and thank you for the opportunity. As you know, the counties are the ones who operate the county tax claim bureaus, so are basically going to be the ones who will be responsible for implementing the provisions of these bills to create this pre-registration process. So I just want to provide a little bit of background in my few minutes on our tax sale process and what this would mean for counties. For us, we're the entity that most frequently collects the delinquent property taxes on behalf of all of our local governments. So we have a process in Retzel and the real estate tax sale law whereby if those taxes are not collected in about a 21-month period, we take those to an upset sale process. If they're not sold there, there's a judicial sale, repository sale, and so forth. The key point of Retzel that I want to emphasize that Representative Heffley just made is that the current law already prohibits an individual who has their landlord license revoked, who has delinquent property taxes in any taxing district where the property is located, and has outstanding municipal utility bills, are currently prohibited from getting the deed transferred to them post-tax sale. This bill does not change that criteria in any way. It keeps, as Representative Heffley said, the bar exactly where it is. The change would be that the law right now says that post-sale, a municipality has 20 days to challenge someone who's purchased a property because of and has any of those outstanding factors. These bills would allow us put in statute a process where we can register bidders ahead of time and have them verify that they are already eligible to bid. So instead of waiting until the post-sale process, we can do this on a pre-sale basis. As we've heard, tax sales properties can be very tempting to bad actors. So we see folks, and we can't always capture them with the post-sale process. I think that, so for CCAP, we support the concept of this bill very much. We know, you'll hear from the tax claim bureau directors here in a few minutes that we have some counties that have already established their own process like this as a best practice, and they're having good success with it. So what the bills do is kind of memorialize that practice in statute that we're hoping will encourage more counties to look at it as an option for use in dealing with the same issues in their counties. There's a couple of really good points to the bill. One, it also lets us get at delinquent taxes and municipal liens across the Commonwealth that a potential bidder might have. So right now, we can only look at those that are in the municipality where the property is located. It does not put an affirmative duty on the county to go out and search the entire Commonwealth for those liens and those back taxes, but we know our tax claim directors talk to each other. We know that there are quote unquote frequent flyers of bad actors, and so they know who those folks are, and then they could better vet those folks and try to capture some more of these bad actors that we can't get to right now. It does put the compliance on the individual to confirm on their affidavit that they do not have those. The big thing about these bills for us is that we do believe that they should be optional rather than mandatory. We understand the pre-registration has been a great tool for many counties, but we also know that there are other counties who've developed other ways of working with their municipalities, for instance. And cooperating with their municipalities have been just equally effective in getting at some of these bad actors. And we know from some of our counties in our more rural areas, they take very small numbers of properties to their tax sales. So for instance, one of our 6th-class counties reported exposing just 36 properties to their tax sale, another just 60. So for them, creating a registration process and going through all of this would probably, the cost-benefit analysis just wouldn't equal out for them. So we think that optional would be preferable. We also know too that at least one of our counties allows for pre-registration by mail, and there's some discussion, I think, to be had on that point. There certainly is a preference to having somebody come into the office, being able to verify they are who they say they are. But again, in some of our rural areas, even for folks who are local in the county, that coming in person may keep some folks who we do want to get properties from getting into the office and getting pre-registered. So some additional discussion on how we make sure that we're balancing keeping those bad actors away from properties, but also not discouraging the good actors from getting these properties and putting them back on the productive tax rolls. I think that further discussion is warranted on that point. Some of the prior testifiers had also noted this issue of shadow LLCs. We absolutely see that at the county level, where folks will come in and register under a different LLC name that doesn't have back taxes or outstanding property code violations, but the individual who's behind it has another LLC that does, and because they're registering under a different LLC, we can't violate them under the law and keep them from getting properties. So we think that it would be beneficial to explore that further, how we can address that particular situation. We know the Department of State might have some data that access to that might be helpful to our counties in getting a better understanding of who's all behind these different LLCs and working through that process. We've been asked to comment on the 2 proposed amendments. The one that limits based on distance, I think we've talked that a lot of the folks who have these outstanding violations are from out of the community. 250 miles, though, as we've heard, is kind of a de facto statewide blanket, so that we can't really, we're assuming that all the bad actors are basically out of state, and we're only asking these out of state folks to register. And I think what you're going to find is that while they might not be from the community directly, there is more local and more regional problems that do happen, that it would be helpful to not have that distance put in the statute. The other amendment that I just want to touch on is dealing with, it takes out the language that would prohibit immediate family members from being able to purchase a property out of judicial sale. That language that's in there we think would be helpful. We'll note that when a property gets to judicial sale, it is being sold free and clear of all liens. So by the time a property gets to that point, if a family member is waiting out to that point, they're basically waiting for a chance to wipe clear the liens of their family member. And there are multiple opportunities for an individual or anyone else to pay off the taxes, to pull it out of the tax sale process prior to, and to deal with it up to the point where they would get to a judicial sale anyway. So I don't think that having that language in there prohibits opportunities to get family-owned properties back in those hands, if that would be the case. So with that said, I will stop and see if there are any questions.
Thank you so much. Any questions from members? Okay. Seeing none, thank you so much. We appreciate you being with us today. And next we're going to have a panel Stacy Pyle, Director of Berks County Tax Claim Bureau and first legislative officer of the Tax Claim Association of Pennsylvania. And she's joined by Rachel White with the York County Tax Claim Bureau and Renee Roberts, Director of Carbon County Tax Claim Bureau. We appreciate you all being here today, and we welcome your remarks.
Good morning. My name is Stacy Pyle, and I'm from the Berks County Tax Claim Bureau. I'm also the first legislative officer for the Tax Claim Bureau Association. So am I too far away? I'm usually really loud, so I'm sorry. If it gets too loud, I apologize. We wanted to just thank you guys to give us the opportunity to speak, as we are the soldiers on the field. We all run the tax claim bureaus, so we have firsthand experience on what it is like to work in the tax claim bureau. I have been the tax claim director for 13 years for Berks County. So I can tell you that tax claim bureaus initially, we are created to collect taxes. We are not created to sell properties first and foremost. I can speak on behalf of Berks County. We start out with 9,000 delinquent taxes every year. By the time we go to our first tax sale, which is the upset tax sale, which takes 21 months, we expose about 250 properties. So we go from 9,000 to 250 that we will expose to sale. The upset sale price is set, the opening bid to sell a property at an upset sale, just so everyone understands, includes all of the back taxes. It includes unpaid municipal liens, and it also includes Commonwealth state liens. So when a property is exposed at an upset sale and it's sold, we are collecting enough money to pay back all of the back taxes as well as the unpaid municipal liens, as long as they're provided to us as the Tax Claim Bureau. We generally will expose about 200 to 250 properties at our upset sale. We will only sell 20 because, again, these properties are being sold with all of their liens. So a lot of purchasers don't want to purchase those properties because they don't want to take on that debt. They don't know how to do the homework. They don't understand. Once a property has been exposed to an upset sale, it now moves to what's called the judicial sale, which is also known as the free and clear tax sale. By the time I expose my properties to a judicial sale, my list drops to approximately 100 properties. I will sell 99 of those properties at my judicial sale. My judicial opening bid amount is simply the cost that I have spent in the Tax Claim Bureau. I had to advertise in the newspaper. I had to send the sheriff out to post the property. So my opening costs are maybe $900. So my properties start at an opening bid of $900. So it generates a lot of potential bidders to come to my sale. In June, I had 585 people registered for my judicial tax sale. I in Berks County do have pre-registration. I require every registered bidder to come into my office. I require them to fill out a form, sign an affidavit. If they register under a corporate name, I require them to show me the corporate documents that that corporation exists, in addition that they have the authority to act on that corporation, and I make a photocopy of their driver's license. I then take that list, and recently last year was the first year I sent my registered bidder list to all of my municipalities. In anticipation of this bill coming through, I wanted to see how the process would work. I sent the list to my municipalities 14 days in advance, asked them to respond to me in 5 days so that I would then have time to contact that bidder to say, look, the city of Reading says you're not allowed to bid. You need to go work that out with the city of Reading. I don't know what the problem is. I don't care what the problem is. The issue that I found in the city was that my registered bidder that came in to register was Jose Gonzalez. Well, in the city of Reading, there's probably 400 Jose Gonzalezes. So they wanted to ban my gentleman who owned no properties in the city of Reading. So that was a hiccup that I experienced just recently. As far as no other municipality, I have 76 municipalities in Berks County, no other municipality responded to my list with code violations, with anything. The only municipality that responded was the city of Reading. And so the morning of the sale, I read the bid number 989576. You will not bid at my tax sale. You need to leave my tax sale. And I had a sheriff escort them out of the room. So that's how we handled it. And I just wanted to give you a brief overview of kind of how the tax claim bureaus work as a whole and what we do. As far as these potential bills are, as a tax claim association, we met at our fall conference in the third week of October. There were 34 counties there represented by the state of Pennsylvania, and we discussed these bills in length at our conference. And as a majority, we are in favor of the bills, and we do support the bills. There's just minor tweaking in language and different things that we would like to see changed. For an example, in the one section, under section 501A, it indicates that a person that intends to bid at a scheduled sale must appear and register. Scheduled sale is not defined anywhere in our statute. So the question becomes, is that an upset sale, a judicial sale, a repository sale, a private sale? It's not very clear. With a repository sale, we have to have the consent of the municipalities anyway, so it would seem redundant to require pre-registration for a repository sale or for a private sale. It seems that it would work better for a judicial sale and an upset sale. So if that language could be cleaned up by just clarifying those tax sales instead of keeping it vague with the word scheduled sale. In addition, as far as sending the registered bidder list, to clarify, you know, for me, I have 76 municipalities. I don't want to print that list of 500 bidders, put it in a mail, and mail it to my municipalities. I can email it. I have everyone's email address. It's super easy to email it or to fax it. Is a lot faster and easier for us as the directors. In terms of our upset sale, like I'd indicated, my tax sale list, upset sale list, is created on July 1st and has 4,000 properties on it. By the time the upset sale comes in September, I am down to 200 properties. So our offices are very busy, and we are heavily hit with people coming in and making payment plans and paying their taxes. 2 weeks before the sale, I don't have a lot of time as a director to focus on bidders coming in. So I need to make the process as simple and easy as possible procedurally for me and my staff, so that A, I know that I do it and it gets done correctly. So putting so much burden on us isn't feasible. Again, we're not here to sell properties. We're here to collect taxes at the end of the day. It is, you know, my solicitor's famous words, as well as, you know, I've stolen them from him as well. And as I had indicated before, it's just minor language changes, I think, that we had focused on wanting to change. And I guess, really, ultimately, for me, it's educating the bidders more so than it is banning the bidders. So in Berks County, at my tax sales, I will lie and advertise that the tax sale starts at 9 o'clock. And at 9 o'clock, my 400, 500 people come in, and I will conduct a Q&A session. And I will say, okay, if you purchase a property, if you have not gone to the property, please do not buy the property. If you haven't visited the city to see if there's code violations, or if the property is dilapidated or falling down, or the back of the property is missing because there was a fire, then please don't bid on the property. I try to educate them and explain to them what they're getting, and so that they understand the opening bid is $900. You are not buying a mansion. You are not going to turn around, walk in this house, and it's going to be beautiful, and you're not going to have to do anything to it. You know, the water authority, the municipalities are going to come after you because it has been sitting for so long, and it has a lot of violations on it, and everyone just wants it fixed up so that it can become a livable property again. So we do a half-an-hour Q&A session, which I feel helped. I think the biggest issue as the association that we all talk about is, and we all share an email collectively as a group. There are, I think, 170 members on that email in the tax claim bureaus across the state. We have a lot of registered bidders that register under multiple company names. So they know that company ABC has delinquent taxes and already bought a property. So they'll just create another company, register it with Pennsylvania, come in with the paperwork for me and be like, oh, Stacy, I'm now company 123 Inc. And I have to allow them to register because there's nothing in the statute that stops me. And that's probably, I know, a huge thing, as well as the banning bidders or not allowing bidders that are delinquent in other counties. I don't have access to see that, but I have emails, and I know who Rachel's bad bidders are from York County because we email each other. Hey, did so-and-so come to your tax sale? We all know who they are. We all talk amongst each other. And that this bill would allow us to be like, oh, we know he has delinquent taxes. Yay, we can tell him no, and we now have the law to back us in that sense. I don't know. I know it's a lot of information. I don't know if I know I speak too fast, so I apologize.
The family members is the only other.
Oh, and yes, the definition of the family members is important to us, especially for a judicial tax sale. You know, I had a gentleman's father come in and bought his son's property at a free and clear sale, wiped out a $40,000 mortgage on the property, wiped out $4,000 in back taxes, and dad bought it, and then 3 months later, dad conveyed it back to the son, and I had no way to stop it. I knew it was the father because someone in my office was the neighbor and knew them personally. So to us, I think that language is important to define family members and immediate family members from not doing that, because it's not fair to the rest of the taxpayers in Berks County who actually pay their taxes. I mean, if it's that easy, we could all just stop paying our taxes, let it go to tax sale, and have our parents buy our houses, free and clear. So I think those were the big issues, or not really big issues, minor issues.
Okay, we've got a few questions. Any additional comments from Rachel or Renee?
May get to them with questions.
Okay.
Stacy pretty much covered it.
Okay, very good. Senator Argel.
One of the challenges in dealing with this issue over the last couple of decades is exactly what you'd identified. How do you crack down on the bad actors without hurting the good ones, the legitimate versus the illegitimate, the educated versus the clueless?
Right.
I'm sure you have, well, it wouldn't be your county, but we see that, you know, when people are buying these properties, they don't know the difference between Pottsville and Pottstown,
Sure.
okay? And so I'm curious, how, is this a minor tweak, or will this really produce some major results if this legislation passes with the amendments that you've suggested?
I think that, to be honest, even though it's not in our statute, I think a lot of us are already doing a pre-registration, and we're already vetting our bidders. I know Rachel does it in York County. Carbon County does it. We don't necessarily send the list to the municipalities. Rachel, I know, does that. Again, that was something I just started this year and last year. I'm not sure if you send it, but I at least require them to physically come in to verify that John Smith is registering for my tax sale, and he really is John Smith. I make him give me a photo ID. I ask for his current mailing address so that if he does buy a property, I at least have the right guy and can send him notices. So I think as a whole, some of us are already doing that. So I don't know what more it will help with. Maybe with sending it to the municipalities in advance and allowing them the opportunity to say, hey, this person owns a property that has caused a health and safety condition, so don't allow them to buy any more properties. Then yeah, that's a huge advantage for us, and I think that will help.
Yeah, I think, if I may speak, I think a lot of it also is moving it to be preemptive instead of reactive after the fact. Because if we end up dealing with it 20 days after the sale, that property then sits there for another year before I can relist it and then get it back through another sale. So if we have the legal standing to be able to do these preemptive measures ahead of time, then it will certainly help us ward off a lot of those issues. I get money in after my registration. I get a lot of tax money in because someone wants to bid. Mm-hmm. There's a property on the list they want to buy, and they know they have delinquent taxes on other properties, so they will pay them in order to bid. So they'll maybe pay them sooner than what they wouldn't ever let their own property get to the sale, because a lot of the people at our sales are, good investors, and they do keep coming back. But they still work the system, right? So they're not going to, they'll just pay those taxes a little earlier.
Do you see any negative impact on legitimate businesses as a result of this legislation?
When I shut my registration down 14 days early, I had some bidders call me all irritated. Well, I'm from New York and I got to come down. I'm like, listen, you're buying a property at a tax sale. I'm not a realtor. I was like, and yes, it's an investment property. So if you're truly interested in the property, you should come and see the properties. And then you shouldn't rely solely on Zillow or Google Maps because the building might have been there in 2015, but is no longer there. So you should drive by it to see it. And so I think the first year I did it, I got a little pushback from my bidders like, oh, Stace and blah, blah. But it's been fine ever since.
So I'm going to put that down as a no.
No.
All right, thank you. Thank you.
Sorry. The long-winded answer would be no.
Thank you so much. Representative Helm.
Thank you. I'd just like to hear your comments about a statewide database. Do you think it would be appropriate to create one?
I think it would be amazing to have one. I think in Berks County, we are currently in the process of getting a new system for tax claim. I don't know how you could we all use different computer software systems for collections, so I'm not sure how you could take that data to put it into a database that would be viewable on a county level. I think it would be great if it could happen, absolutely.
Well, can I just add to that also? I know the law, the way the statute reads right now, says you can't buy a house in this municipality if you own taxes in this municipality. The county is a taxing authority in of itself, so in my mind, if they owe taxes in any municipality within my county, shouldn't they be paid before they are allowed to bid? So that definition would certainly help us too. Even though I can't look outside of my county, I should be able to say, no, you have delinquents, period, in my county. So opening it up for us to possibly be able to look across county lines, absolutely. Having that in there would most definitely help because we do talk, especially when there's, those common names. We all know certain people. So yeah, having it there, whether we can do it yet or not, having it in place so we could do it down the road would be of great benefit.
I like your answer. I know we're trying to figure out how you can do it. That's the challenge, but
I think
I'm glad to hear you think it's a good idea.
I think it'd be great.
Ashley Schaefer has a question.
I just have a question about the family member provision. I know there's been some concerns about having that in there and how that could negatively affect certain people. And I just kind of as a thought, instead of, the amendment would remove it completely, I just was curious on your feedback. What if we did something where you cannot transfer the property after you purchase it at tax sale to another person until it is brought into code compliance? Or they could get some sort of waiver from the municipality saying, okay, we approve you to go ahead and transfer that property without correcting those code violations, instead of an outright prohibition on family members purchasing.
Well, I think the issue with that is that your municipalities don't collect delinquent taxes. The tax claim bureaus do. So we're the ones that have that information, not them. So if the property has the delinquent taxes and it sells at a free and clear sale, those taxes now get wiped clean. And so if the father purchases it and then 3 months later conveys it back to the son, I don't know what codes really would do to help that situation. You just wiped out all of those back taxes as well as mortgages and any other liens that are being held against that property. So I don't know, getting a certificate from your municipality, it still doesn't, selling it at that free and clear sale is the moment it wipes out those taxes. So transferring it later doesn't prevent that, or having a certificate doesn't not wipe out those taxes.
Can I ask you a question? You said about it, you were concerned about it affecting the family members. Like, what, can you give us a scenario?
There's just been scenarios raised about an elderly, let's say there's an elderly homeowner and they haven't been keeping up with their taxes. The property goes to tax sale and the family member goes, hold on, I'm going to buy this property so they can stay in their home.
What would be cheaper for that family member is to come in and pay the back taxes,
right, yeah,
and not buy the property at the tax sale, or come in and get on a payment plan for the back taxes for that, because anyone can pay taxes. We'll take money from anyone, right? So it doesn't matter who comes in. So I think that my response to that would be they shouldn't be waiting to come to a tax sale to buy it anyway, because what if they got outbid? Now grandma's going to be homeless. You know what I mean? They should come in and get on a payment plan and work out something with the tax claim bureaus to pay the back taxes, I think.
Thank you. We've got time for one quick question. Representative Jones.
Bidders, they're being asked to qualify like every time there's a sale. I mean, is there not a scenario where we could say this is a qualified bidder and they're good for like, go to York, they qualify, there's another sale 2 weeks later, or are there not that many people bidding that frequently?
I think that it's easier, I guess, procedurally with our systems and the processes that we have in place. It would be too hard for me to be like, okay, John bid at my upset sale. Where am I stashing John's information so that when he comes back for my judicial sale in June, I can repool all of that information? I don't have a system that can hold all of that. I do it now all on spreadsheets. So I'm not sure. So for me, I would rather require them, and I do it that way. I hold 3 tax sales a year, and I just require them every tax sale to come in. And they're buying properties at a very low value, and so we don't get a lot of pushback with regards to that. I don't think, because of that reason.
That answers it. And then, and this is another one that may or may not. I might not be reading it. Maybe I'm not reading it correctly. Or if some of the people fail some of these criteria, it sounds like we're dictating they can't bid, as opposed to you making a decision. Is there a scenario, for example, that, I'm down in York County, so maybe we've got somebody who's a really good landlord with a great track record in my little town, in my town of Dallastown, but they had a little beef with the city of York, and the city of York said, we're revoking your landlord license over one property. So you potentially have a known good actor who had maybe a little bad incident, and why are we dictating that just versus saying we're making the information available to you so you can make an informed decision, not us necessarily telling you who can and can't bid? Or maybe the bill doesn't do that, I don't know. State dictating who can bid, why don't we just dictate what information is made available to folks like we've heard and let them decide if they can.
Yeah, the criteria is already in statute in Retzel, so we're just following that same criteria. We're not changing any of the criteria. Right now, the process is if somebody does bid, they then have to have 20 days to go after and prove that they weren't eligible to bid. All we're trying to do is get them to pre-qualify rather than try to go to that whole system, which is expensive and a legal process to get the property back. So we're not changing any of the requirements. It's already in statute.
Thank you so much. Thank you, ladies. We appreciate your time and your testimony. Our next witness will be Andrew French, who's the Executive Director of Redevelopment Authority of Fayette County and legislative member of PA Association of Housing and Redevelopment Agencies. Mr. French, thank you so much. Thank you for being here.
Good morning.
Good morning. You can begin when ready.
Okay, as you indicated, my name's Andrew French. I'm the Executive Director of the Fayette County Redevelopment Authority. And today I'm representing our state association, which is the Pennsylvania Association of Housing and Redevelopment Agencies, or PARA. PARA has 225 member organizations, either housing authorities, redevelopment authorities, or affiliate members, and we work across the Commonwealth. As Senator Argel indicated, we are on the front line. Many of our members are kind of spearheading blight initiatives in their different communities. In Fayette County, we've been in charge of dealing with blight since our inception in 1949, which is what redevelopment authorities really were created to do. I'm also proud to say that in 2018, we became the first county in the Commonwealth to adopt an ordinance allowing us to, as a redevelopment authority, to have the same powers as land banks, which was legislation that was initiated by both of these committees, and we obviously appreciate your support. Just in the last 10 years in Fayette County, we've invested about $65 million in various initiatives. About 7.1 million of those has dealt with blight. So we do a lot of rehabilitation programs to try to stem that blight, but unfortunately, a lot of our communities are extremely blighted, and it's the last resort, as obviously we're pursuing demolition. As I indicated, we are the last resort, so oftentimes redevelopment authorities and community development agencies that are dealing with blight, we get involved in the end when all other recourse is not an option. So it's already a lot of things have been exhausted in the private sector, and oftentimes we're coming in at the end to remedy the blight. In my testimony, I kind of relate a couple of scenarios that we encountered in Fayette County. One of which was a property owner that came through our homeowner rehabilitation program to receive assistance to bring their home up to code, and it was in one of these patch communities that we have in the county. So where they used to mine for coal, and it was a patch home, so they're duplexes. You've got two sides. Well, we discovered that the homeowner did qualify for our program, but the home that was attached to her home was falling down. And when we did more research, we discovered that it was owned by an LLC. We had tremendous difficulty finding out where the principals of that LLC resided. We did eventually find them. We also discovered that this particular LLC that was actually headquartered in Las Vegas, Nevada, had purchased about 44 different properties in the county over a span of about 10 years, and this was one of them, so they were sitting on it. We also discovered that once we found the principal of the LLC, they were actually in a penitentiary in Las Vegas, Nevada, for similar fraud purposes. So in the end, we were able to intervene because they didn't pay their taxes. And it was repeated over and over again that these companies, they come in, they purchase the property. This particular property they bought for $168 out of the county's repository. They purchase the properties, they try to flip them or market them using sites like Craigslist or something like that. But this one they obviously couldn't sell. And so the cycle repeats itself. So it goes back into the 3 years of delinquent taxes, goes back into the tax sale. And we were actually able to secure the property through the county's repository by intervening and purchasing the property. I will say too, even though this unique situation dealt with an absentee property owner, somebody who was out of state, we also have local potential developers that are doing the same thing. One of our communities, there was a potential, he was a nefarious developer that purchased over 120 properties, many of which were through the tax sale. All of those properties are now in the repository. So he purchased 120 properties. And I think if these bills were to have been in place, obviously that would have been halted at some point because the municipality would have alerted the Tax Claim Bureau that this particular individual, as he was acquiring these properties, wasn't dealing with the code enforcement issues that plagued his properties. So those are just two examples. Again, we see our particular county Tax Claim Bureau, they have about 300 properties in each tax sale that they administer each year. And then we also have a county repository that has about 450 properties in it that, again, people are purchasing the properties relatively cheap. So on behalf of PARA and our members, we do wholeheartedly support this legislation. We think it would be of benefit not only to our members, but also to the municipalities that we work with. And with that, I'll open it up if you have any questions.
Thank you for keeping your comments brief. I don't see any questions, but I just have one quick question. What are your thoughts for making the bill optional rather than mandatory?
I think, and I can understand potentially that there might be some communities that would struggle with that. I think PARA would support making it mandatory just because it would I guess, further strengthen the bill for the communities across the Commonwealth.
Okay. Okay, Rob Gardner.
Sorry, I've been hiding in the back. Quick question. You mentioned that all 120 properties turned over to you. Does it make sense that some sort of change needs to be made so that it's easier to transfer properties to redevelopment authorities like yours prior to it, having to go through a second or third round of these, bad actors buying the houses, forfeiting on them again? Should we look at some sort of change in the repository law to, in the case of a county that has a redevelopment authority, turn those properties over to you instead of selling them for $130 and getting them back in 3 years?
Yeah, and I think that Act 33 of 2018, which provides redevelopment authorities the same power as land banks, accomplishes that. We're actively going in to the county's repository and purchasing property. Obviously, we're prioritizing and trying to identify the most strategic properties because we've got limited resources. So I can't go in and take all 400 properties that are in the repository. We're trying to focus kind of on those high priority properties. So I think having those abilities, it is easier for us to act in that capacity.
Yep. Thank you very much.
Thanks.
Thank you, and thank you so much for your time today, for your comments. We appreciate it greatly. Thank you so
Okay.
much.
Thank you.
Our final testifiers are Winnie Branton, who is the Blight and Land Bank Training and Technical Assistance Program Manager with the Housing Alliance of Pennsylvania. She's joined by Lavanna Landecker, who's the Deputy Director with the Housing Alliance. Ladies, thank you so much for being here with us. I apologize, we got a little bit behind in time, but we're anxious to hear your comments. Who would know that there's so much interest in blight, right? But thank you.
Thank you. Thank you for inviting us here this morning. The Housing Alliance is a statewide coalition that works to provide leadership and a common voice for policies, practices, and resources to ensure that all Pennsylvanians, especially those with low incomes, have access to safe, decent, and affordable homes. The Housing Alliance promotes common sense solutions to balance Pennsylvania's housing market and increase the supply of safe, decent homes for low-income people. In the context of that mission, the Housing Alliance has also taken on the Blight banner, along with Senator Argall and the statewide Blight Task Force and many of the partners who testified here this morning. Tax sales present an opportunity, as Stacy testified, to collect overdue real estate taxes, right? But they also provide an opportunity for buyers to get properties at deep discounts. So requiring buyers to jump through a couple hoops in order to get access to those properties is reasonable, and it supports the scrutiny that's necessary to ensure that those purchasing the properties have the resources and the capacity to bring them into compliance. So the Housing Alliance is here to say that it supports SB 775 and HB 1559, and we offered some comments and recommendations in our written testimony that was submitted. But I was going to start off with Senator Argall's question that if you pass the bill, how would this help? And there's three things that I want to highlight. One is there's a pool of potential bidders that want to go to these sales. So by requiring pre-registration, what you're doing is looking at these bidders in advance of the sale in order to see if they meet the already established criteria under 619. You don't have to wait until post-sale, file a court case, and proceed that way. So you're looking at the pool of potential bidders and you're saying, hey, look, under the law, you're already not allowed to bid. So we're taking you out at the beginning and not requiring the process post-sale of litigation. So that's number one. Number two is that when dealing with problem properties, what's critical is information, right? Information is the key to figuring out who's responsible and trying to hold them accountable for taxes as well as code. So what the bills do is provide information to the Tax Claim Bureau, which then shares it with municipalities regarding the entities that are purchasing these properties, so that they have it now and they have it if they are the winning bidders. For instance, when we talk about LLCs and the information that is often held private, one of the recommendations we had is that the application require additional information where an LLC is the applicant, the bidder. Where the applicant is a LLC, require that the application include the names of all members, managers, and any other persons with an ownership interest in the LLC. Right now, the legislation just talks about officers, and that suggests that maybe it's not an LLC because those partners are usually referred to as members and managers. So just to clarify the language so that it incorporates identifying those members so that when you get to the point where there are issues or when you're scrutinizing for compliance with Section 619 and Retzel, you have the information you need to make that investigation and that assessment. The other point that I wanted to highlight is that when you're having the affidavit that's required under the law for pre-registration, that there be included in that affidavit language that says if you don't tell the truth, that you're subject to state penalties for not telling the truth. Just another reminder that this is serious, this is real, don't lie, and you'll remain above reproach. Sharing the list of registered bidders with the municipalities is critical. So that list being shared 14 days in advance, I understand that as a burden and could be a burden for the tax claim bureaus, but reducing it down to 36 hours would just really water down the benefit provided by sharing that list with municipalities. As Dave Patton testified, that would not give him time to review it. And working with the municipalities through the Housing Alliance, that would be the case as well. Sorry about that. So so for those municipalities, they need the time to review it. And as this becomes more indoctrinated, I think that the counties will see a better response from the municipalities in terms of understanding what the rules are under Retzel and how they can disqualify bidders at tax sale to prevent that from happening. The last thing I want to mention is repository sales. The repository sales, you can purchase properties for as low as $200 in some counties. And the bill here talks about adding responsibilities to set a minimum purchase price. That seems reasonable. Requiring as a condition of sale that the purchaser sign an affidavit similar to what's required for a judicial sale makes perfect sense to me. And hopefully that will allow some of the repository sales to be not consented to by municipalities, because right now Retzel provides that consent may not be unreasonably withheld. And I often get questions from municipalities as to what does that mean? Like, what are the grounds for me to say that I want to withhold my consent from a repository sale? So having language in this bill that would say or qualify the fact that if you don't sign this affidavit or if you don't share the information, you could also include a requirement that a person who wants to buy a property from the repository list has to make an in-person appearance as well, so that you can have that conversation. What are your plans for the property? Are you really committed to redeveloping the property? Because the repository list properties are really the bottom of the barrel. No one has bid on them through the judicial sale where all the liens are cleared and it sits in the repository and continues to deteriorate and leaves municipalities often with the burden of having to take care of those properties when no one else is available or around. So in conclusion, the Housing Alliance supports the bills. On the two amendments that were offered, the reducing the amount of time to 36 hours, that would not work to satisfy the objectives of the bill. On the immediate family members, again, the history and experience has shown that family members do use this as an opportunity to start fresh for their family members and avoid paying taxes. There are also existing remedies under Retzel where counties can have extensions of time for seniors, and there's payment plan obligations. I think it's section 503.1 of Retzel and 504. So there's remedies in there that can address some of the issues that have been raised about immediate family members, and we would hope that those amendments would not restrict any further the scope of the bill, which we think would really do a good job at helping to avoid having buyers come to these sales who are ineligible under Retzel already, purchase the properties, and then have the municipalities later either have to challenge in court or deal with the bad actor property owner.
Thank you. Lavanna, any question, any other further comments?
I don't have anything to add. I mean, Housing Alliance feedback that we get from communities is that this would be a great way for them to be able to manage their properties. So we thoroughly support it, and I think Winnie summed it up very well.
Yeah, you all are boots on the ground, and you see a lot, and so your testimony here today is very important to us. Are there any questions, any further questions? Okay, well, we're going to thank all of our witnesses today for being here and taking time to share their thoughts and comments on Senate Bill 775 and House Bill 1559. I think we've all learned quite a bit, and it's been helpful as we move through this process with these two bills. Our hearing is closed today. Thank you again, everyone, for being here.